Hey everyone, I'm Liam, and I'm a member of the team known as the best team in this course. Today, I'm just quickly introducing that we're going to provide a video on the case of the Law Society of New South Wales versus Cummins. This was a 2018 case where a New South Wales tribunal found a solicitor guilty on 2 grounds of professional misconduct. Our analysis examines the tribunal's judgment through ethical lenses that we've studied over the past 8 weeks, and in this video, there's going to be 5 parts. Maggie's going to present the facts of the case, Mingy's going to analyse the legal principles, I critique the tribunal's fairness, Logie applies behavioural ethics, and Shuyan discusses values in practice. We hope you enjoy the video, and if there's any questions at the end, we're happy to answer them.
Our main character, Mr. Paul Bernard Cummins, was first admitted as a solicitor in 1970, but things didn't go smoothly. In 1983, he was struck off the roll. 13 years later, he was readmitted, but with strict conditions, which includes he could only practice as an employee in a law firm. Otherwise, he violated the conditions of his undertaking and practicing certificate. Fast forward to 2014, Cummins is helping an old friend, Rain, a former Catholic priest facing criminal charges for sexual offenses. Cummins appeared in court to help him apply for bail. In a total of 4 representations, all appeared in his own right, but the point is, according to his undertaking and practicing certificate, he should not have been there without the support of a supervising law firm. In 2016, Cummins was back in court. This time he acted for Ryan at sentencing hearing. He was worried that his former client was being pressured into pleading guilty and decided to voice his frustration to the barrister. In a heated moment, he verbally threatened the barrister to report him to the Bar Association, but in fact, there is no reasonable basis. 3 days later, the barrister lodged a formal complaint with the Office of the Legal Services Commissioner, alleging that Cummins' statements was an attempt to intimidate him. The office then referred the complaint to the Law Society for a more in-depth investigation. During the investigation, the Law Society found 4 disqualified attendances since 2014. As a result, Cummins faced 2 charges of professional misconduct. This all reached a crunch point in 2018, when Cummins admitted had crossed the line and made an apology to the barrister. However, he also considered that the fine of $5,000 demanded by the Law Society was too high. After all, he was 76 years old and in poor health, and could not afford to pay the fine. The society therefore agreed to reduce the fine to $1,000. In return, Cummins promised that he would not reapply for a practicing certificate, so that he would not risk being struck off again. Instead, he would receive a formal reprimand, a modest fine, and be required to pay his opposing party's legal fees.
Hello everyone, my name is Mingyi and I'm going to talk about the tribunal's legal framework and analyze. In ground 1, the tribunal cited both the LPA and the LPUL. This is because the LPA was the relevant legislation in force when the solicitor's conduct occurred in 2014, as he did not comply with the conditions that his right of practice was limited to an employee. However, by the time of the case being decided in 2018, the LPUL has replaced the LPA, so the tribunal also cited Section 54 of the LPUL, allowing them to align their findings with the current legal standard while still considering the time of the conduct. They also applied Section 297 to establish that the solicitor's conduct met the definition of the professional misconduct because his appearance did not reach a reasonable standard of an experienced lawyer. But the tribunal considered, not cited Rules 3 to 6 of the solicitor conduct rules. He did not apply for a legal aid at his first appearance, which was against the best interest of the client in Rule 4. Rules 3, 5, and 6, considering a solicitor's duty to the legal system and the undertaking, was relevant as his branch would dismiss the public confidence in the administration of justice. Case law including Javadina, Sin, Grago, posted by the Council showed the tribunal's approach to breaches of different conditions. In Ground 2, the tribunal cited only 3 cases to provide context for evaluating conduct involving threats because the threat was an ethical issue, although Section 562 of the LPA and Section 302 of the LPUL empower the tribunal to order the removal of a legal practitioner's name from the role. The tribunal also cited NSW Bar Association and Cummins to show the strict text for the order, and his threat was not as serious as these cases, considering other factors like age.
Appropriately following on from the relevant laws of lawyering principles in the case of Cummins, this analysis is now going to show how the tribunal failed to ensure fairness for the public and for the justice and its administration in New South Wales. First, ethical standards demand serious consequences for repeated misconduct. The tribunal failed to consider Mr. Cummins' 1983 disbarment and later unethical acts as a clear pattern of this conduct. As Barron and Corbyn emphasised, a lawyer's duty to the court, quote, supersedes personal interests. However, this supersession was not in the case of Cummins. Despite restrictions and knowing them on his practicing certificate since 1996, Mr. Cummins represented himself in 2014 4 times and breached those terms. The Law Society found his actions to demonstrate long-standing unethical behaviours, but this was not the case with the tribunal. Even though they had the power under Section 3022F of the Uniform Laws to disallow him as not a fit and proper person, they chose not to. This undermines public trust at a very large level. From a socio-legal perspective, fairness is linked to public trust in the justice administration. By treating Mr. Cummins' age as a mitigating factor, him being 76, the tribunal lowered accountability standards. Barron and Corbyn emphasised that civility and courtesy are vital for trust in the legal system. Yet, Mr. Cummins' actions, such as advising a client already represented by legal age to plead not guilty, exceeded professional misconducts. This was again exacerbated when the tribunal found that it was, quote, in the heat of the moment. What is in the heat of the moment? If we look to cases like LSC v. Ski, where repeated misconduct of a young, mid-20s solicitors resulted in harsher penalties to bolster public trust, we can look to Cummins, where age again was seen as another mitigating factor in the opposite direction for older age. This inconsistency points to unfair judgments by the tribunal. For the public good, Mr. Cummins should have been disbarred considering his history and his age. No one else but Mr. Cummins in 35 years would have a better understanding of the disciplinary framework in New South Wales for professional misconduct. Lubin and Wendell stressed that virtue ethics in law involves assessing both rules and moral character. The tribunals failed to evaluate Mr. Cummins' conduct from this perspective. The penalty, only 9% of the maximum fine under Section 54, was a mere $1,000. Ultimately, the tribunal's lenient handling of Mr. Cummins' repeated misconduct undermines public trust and the integrity of the legal profession in New South Wales. It's our belief that a stricter response on a critical analysis on fairness, disbarment would have been a better decision by the tribunal and would have upheld ethical standards and reinforced accountability in New South Wales.
My name is Logi. The part 3, we will talk about behavioral ethics and ethical framework. First things, we will shortly talk about behavioral ethics and its importance in the legal place. Behavioral ethics concern how professionals make morally and legally decisions when faced with complex situations. Lawyers' actions not only affect the client's interests but also directly influence the public trust in the judicial system. Then we will use the Parker models to analyze this case. There are 3 different steps. The first step is to recognizing the ethical issue. In the first ground, personal factors such as Cummins' overconfidence and pride led him to disregard the limitation of his practicing certificate, believing that his experience justified his lack of the authority to act, even though he knew that the breach had been committed. In the second ground, Cummins' emotional state, driven from the frustration and lack of the emotional control, led him to threat a barrister, which he knew was a breach of the professional conduct. From a situation perspective, legal pressure in the first ground, like the representing a vulnerable client in the limited legal market, compelled Cummins to violate ethical rules. In the second reason, the high-stress courtroom environment led him to emotional outbursts. And in the step 2, we need to consider and choose from a range of criteria. Like the Cummins had other elections, but personal motives clouded his judgment. In the ground one, he could have a supervision of a legal assistant, but bypassed because of the professional pride. In the ground two, he could have resolved the conflict through the formal channels, but his emotional state led him to confront his lawyer. Social factors such as the urgency of the case in ground 1 and the aggressive environment in ground 2 narrowed the Cummins' perception of the ethical election and further motivate him to make an ethical decision. And the last step is to practical implementation. Personal weakness like the overconfidence in ground 1 and the lack of self-control in ground 2 contribute to Cummins' failure to implement ethical behavior instead of the seeking external help. Situation pressures also impede ethical behavior. The urgency of the Mrs. Rain's case in ground 1 and the courtroom dynamic in ground 2 make it difficult for Cummins to act ethically. Thus, is to just depress his poor decision making. That's all. Thank you.
Three-step process of ethics decision-making. Awareness. The firm's infrastructure should emphasize a culture of self-reflection and ethical mindfulness. Structured training on ethical duties, especially the boundaries of practicing certificates, would ensure solicitors are fully aware of their professional obligations. Analysis. Ethical infrastructure would require Cummins to assess the ethical dilemmas through structured support. Firms should implement a system of mandatory consultations or mentorship. Application of chosen ethical course of action should be supported. Cummins could have been guided by firm protocols that required junior solicitors to adhere strictly to certification conditions. 4 models of lawyering. Adversarial advocacy. Cummins' behavior reflected adversarial advocacy but without necessary legal boundaries. Ethical infrastructure could encourage him to balance the airless reputation of his client with legal compliance, ensuring adherence to the practicing certificate limitations. Responsible lawyering. Had Cummins adopted the responsible lawyering model, he would have considered the integrity of the legal system as the need to comply with legal boundaries. Responsible lawyering emphasizes client advocacy and respect for the rule of law and professional integrity. Moral activism. The moral activism model requires lawyers to act in ways that improve the justice system. Cummins could have used his position to foster fairness while dealing with opposing counsel. Ethics of care model focuses on the importance of preserving relationships. Cummins' attempt to intimidate the barrister could have been avoided if the firm had encouraged collaborative conflict resolution. Effective supervision and mentorship within legal practice. Continuing legal education and ethical training. Clear firm policies regarding ethical decision-making and encouraging mediation or conflict resolution mechanism before escalating disputes may help Cummins avoid further misconduct. Giving voice to value. A key principle of GVV is making ethics salient in decision-making moments. Cummins failed to recognize the ethical implications of appearing in court despite his restricted practicing certificate and the consequences of threatening a fellow barrister. According to Dan Ariely's theory of ethical salience, Cummins could have kept a reminder of core values. GVV emphasizes prescripting, preparing responses for foreseeable ethical challenges. If Cummins had prescripted responses to potential client demands or court appearances, he could have communicated these limitations clearly. This aligns with the GVV strategy of planning ahead, which could have helped Cummins navigate these situations. GVV addresses the common decision-making errors that lead to unethical conduct, such as rationalization and ethical fading. Cummins' actions reflected the phenomenon of incrementalism or the slippery slope, where small unethical decisions gradually lead to larger ethical breaches. GVV provides tools to recognize these patterns and resist justifying such actions.
And that brings our video to an end. And like the other groups before us, we hope you guys had fun watching our video as much as we did making it. We've attached our handout in the following 2 slides if there's any interest in the case. And if you have any questions, feel free to ask. I can say that our group, like others in this course, are now overqualified specialists. Otherwise, thank you and all the best for the groups that have the next presentations.